No, we always felt the margin only that only mentioned one, and that's why no relationship process. We were trying to saw.
Good evening. Welcome to Policy Exchange and to tonight's lecture. You're very welcome here. Those who are joining us online, let me just remind you to raise your virtual hand if you would like to ask a question, and we'll hope to be able to come to you in the Q&A later on. For those I've not met, my name's Richard Eakins. I'm Professor of Law and Constitutional Government at Oxford, and for the past 7 years I've had the pleasure of leading Policy Exchange's Judicial Power project. Many of you will know the project aims to maintain the balance of powers in the Westminster Constitution and to address some of the ways in which the expansion of judicial power may put that balance in risk. I'd like to take a moment, if I may, to thank Policy Exchange's Director, Dean Godson, and Managing Director, Julia Mizzen, for their initiative in setting up the project and for their constant energy and support in helping the project make a contribution to public thinking. Tonight's speaker is another person who's made an immense contribution to the project's work. Graham Gee is Professor of Public Law in the University of Sheffield. He took up his chair there in 2015 after teaching for 7 years in Birmingham. His scholarship ranges widely across public law. He's the author of a number of outstanding articles on the political constitution and on the connections between political and legal thought. I've had the pleasure of writing with him on several occasions, most recently in a chapter on the doctrine of parliamentary sovereignty for the volume Parliament and the Law. But his main scholarly focus has long been on the governance, leadership and selection of judges in England and Wales. He was one of the principal investigators in the UCL-based project on the politics of judicial independence and the UK's changing constitution, to give it its full title. His scholarly work on the judiciary has been cited by, amongst other people, the Lord Chief Justice of England and Wales, the Chief Justice of Canada, the Ministry of Justice, the Judicial Appointments Commission, and the House of Lords Constitution Committee. In 2016, he served on the panel recommending candidates for selection as the UK judge on the European Court of Human Rights. Graham has played a leading role in the Judicial Power Project's work from the beginning, curating debate on our website, speaking on our platform, and writing several excellent papers. He's a formidable scholar and a very good friend, and it's a great pleasure to invite him to address us this evening. Graham, the floor is yours.
Thank you, Professor Eakins, for that kind introduction, and indeed for the invitation to deliver this lecture tonight. I feel very honoured to speak from this stage and to do so under the auspices of the Policy Exchange's Judicial Power Project. As Professor Eakins said, since its launch in 2015, the Judicial Power Project has sought to highlight and critique how, in the UK, judicial power has been expanding at the expense of legislative and executive authority. The project has criticised both political and judicial decisions alike that have enlarged the role for national and international courts over provinces of public policy, previously the preserve of the political branches. In so doing, the project has raised awareness of how rising judicial power can undercut the rule of law, effective government, and parliamentary democracy. I've had the good fortune to participate in the project at various points over the last 7 years. But this evening, I want to shift the focus away from the project's central critique of the excesses of judicial power towards, instead, its commitment to judicial independence. Critiquing judicial power is not only entirely consistent with judicial independence, but is motivated by support for it. At the heart of the Judicial Power Project lies a very deep respect for our judges and the important, very often onerous, public duty they perform. The project's critique of rising judicial power is motivated by a desire to make clear to the courts and others the concern that, as Lord Reid put it in Miller No. 1, the concern that the legalisation of political issues is not always constitutionally appropriate and may be fraught with risk, not least for the judiciary. The risk is that the more that judges are forced to depart from the traditional parameters of their role, the more others will see them as pursuing their own policy preferences, culminating our courts being viewed as just another player in the political process. Animating the Judicial Power Project, in other words, is concerned to maintain the traditional limits on the judicial role in order to protect judges from the risk that fuzzy and adventurous understandings of their function may catapult them into choppy waters, which may encourage political forces to question their independence. The context here in the UK is that we have a long, rich, and proud tradition of judicial independence. Like most traditions, there have been ups and downs, highs and lows, light and shade. But ours is an enviable tradition, with our judges rightly respected around the world for their integrity, and the various legal systems in the UK recognised as beacons of liberty, stable government, and the rule of law. Despite this, some worry that this tradition is fragile or under threat, as The Economist put it a few weeks ago. Tonight, I will offer a different analysis. For I argue that what is increasingly fragile is not our tradition of judicial independence, but our understanding of it. As I see it, judicial independence denotes the conditions in which judges are equipped, personally and professionally, to resolve legal disputes impartially, according to law, and free from improper pressure, whether such pressure emanates from litigants, politicians, other judges, or anyone else. It thus encompasses a judge's state of mind when she decides the case before her, as well as material institutional conditions required to foster that mental state. Understood in this way, it expresses the social logic of courts. We want our judges to be independent, to avoid them being induced to decide legal disputes other than through a good faith adjudication of the relevant facts and law. If judges determine disputes other than according to law, or even if there's a suspicion that they've done so, then the social logic of courts as a method of impartial dispute resolution breaks down, with the losing party no longer having reason to accept the legitimacy of that court's decision. Now, the social logic of courts is important in every case, but has a heightened relevance wherever litigants seek to hold governmental actors answerable on legal grounds. In such cases, judges must be independent from the other parts of the governmental apparatus in order to hold those parts accountable for their legal wrongs. Now, from this starting point, it's possible to identify structural arrangements that tend to contribute towards judicial independence. These include arrangements relating to the appointment, tenure, remuneration, deployment, immunity, recusal, and conduct of judges, as well as arrangements for the funding and administration of the judiciary as a whole. Now, it's not difficult, in very general terms, to identify the sorts of arrangements that promote judicial independence. Much more challenging is working out how to implement them in any given polity. A large part of the challenge is the lack of any fixed relationship between formal structures on the one hand and actual behaviour on the other. Experience in new democracies such as Poland or Hungary show us that formal legal structures are no guarantee that judges will decide without fear or favour, or that politicians will respect those decisions where they do so. At the same time, experience in countries with long histories of the rule of law, such as ours, demonstrates that judges can behave independently and politicians respect those judges where they do so, even absent many of the formal structural arrangements that are now often associated with judicial independence. The challenge in any one polity, then, is to arrive at a context-specific package of arrangements which will promote judicial independence, recognising that the precise package will be moulded by a polity's larger political culture. This challenge will inevitably differ from polity to polity, because, to a significant degree, the arrangements that create and sustain an independent judiciary reflect the political and legal contexts in which judges operate. Again, think about new democracies without A History of the Rule of Law. There, the challenge usually stems from the relative weakness of courts, where it can be difficult to foster confidence in courts that were previously closely controlled by the ruling regime. Contrast that with many established democracies with the rule of law, where the challenge increasingly often flows from the relative strength of courts, where the substantial power that courts wield over public policy, together with the willingness of some senior judges to depart from settled legal principle in politically sensitive cases, those things can dent confidence in and support for the judges amongst the political class and the public at large. So my suggestion then is that judicial independence can be straightforwardly understood to reflect the social logic of courts as a means of resolving disputes impartially and according to law. But determining the material arrangements that promote this will be much more difficult, because those arrangements are highly contextual and shaped by the political culture of each polity. And we're at a really interesting moment here in the UK because there are rival assessments of that cultural context in which our judges now operate. On the one hand, those concerned about ascendant judicial power view the government's desire to pursue reforms that seek to re-establish the proper parameters of the judicial role. They view those reforms as a wholly proper exercise of political responsibility. On the other hand, there are some supporters of an expanded judicial role who view such reforms as potential threats to judicial independence, with some describing ministers as, quote, bent on constitutional destruction and pursuing, quote, a vengeful war on judges. Now, in the face of such opposing assessments, it's especially important that we have a clear-eyed understanding of our own tradition of judicial independence. I want, therefore, now to consider some mistakes, as I see it, mistakes which commonly surface in the public square when judicial independence is debated. Many judges and lawyers lament what they perceive as declining understanding of constitutional principle amongst politicians and officials. And there may be some measure of justification for this. But the common mistakes that I have in mind tonight are often found in the thinking of many legal elites in what we might term the legal establishment. To be sure, there are diverse views amongst legal elites, as demonstrated by the contributions of lawyers to the work of the Judicial Power Project, amongst other things. But there are also dominant ways of thinking. And my argument is that the mistakes that I'll identify reflect and reinforce those dominant ways of thinking. Now, some of you may have seen that this lecture was advertised as discussing 10 common mistakes about judicial independence. Well, before Policy Exchange is sued for false advertising, and given that we're in a room brimful with some of the very best legal talent in the country, let me hold my hands up. This lecture was first advertised in March 2020, but rescheduled due to the pandemic, which goes to show what a silly mistake it was of mine to commit to a title 2 years before I actually sat down to write the lecture. There are 6 common mistakes that I would like to discuss tonight. The first is to view the relationship between politicians and judges in overly negative terms, where politics is seen as little more than a foil against which to discern the meaning and content of and rationale for judicial independence. It's a mistake to define judicial independence only in terms of the threat that politics can pose to an independent judiciary, thereby neglecting the ways in which politics helps to cultivate it. Driving this mistake are twin tendencies. The first is a tendency to treat politics as relevant to judicial independence only to the extent that judges must remain above the political fray in order to supply an effective check upon it. The second tendency is to focus on rare, but often high-profile occasions where politicians behave in ways inconsistent with judicial independence. Now, it's true both that judges must remain insulated from the temptations and pressures of political life. It's also true that some politicians might from time to time behave in ways at odds with judicial independence. But the two tendencies I've just described combine to create an overly negative account of the relationship between politicians and judges, an overly negative account which obscures the fact that judicial independence is ultimately a political achievement. Judicial independence is a political achievement in both historical and contemporary senses. In its historical sense, the foundations of a modern independent judiciary took shape on the back of the tumultuous political conflicts of the 17th century. The political settlement emerging from the Glorious Revolution included the Crown respected some of the basic ground rules for judicial independence, with security of tenure for senior judges notably taking public form in the Act of Settlement 1701. In its contemporary sense, judicial independence is realised to a large extent through the everyday practices of a range of political actors, ministers, peers, MPs, officials. These practices include ministers allocating public monies to fund the courts, ministers generally respecting unfavourable rulings in politically contentious cases, and MPs and peers respecting the sub judice rule by refraining from commenting on active legal proceedings in parliamentary debates. These practices are routine, mundane, with their significance easily drowned out by the day-to-day clamour of politics. But these practices evidence the willingness of politicians to behave, for most of the time at least, in ways that promote and protect the independence of our judges. We take a wrong turn, in other words, if we discount or downplay the long-standing and broad-based commitment within our political culture to an independent judiciary. This takes me to a second and related mistake, which is to overlook the many reasons why politicians generally respect an independent judiciary. Several reasons are related to the public interest. Independent courts can not only limit political power by holding governmental actors to account, but also can support its exercise by guiding it towards socially desirable goals, resolving coordination problems, and providing the legal certainty essential for economic development via the consistent and uniform application of rules. An independent judiciary can at times also bring benefits directly related to the electoral self-interest of politicians. For example, by allowing ministers, for better or worse, to displace responsibility for unpopular decisions to the courts. Relatedly, in a competitive electoral environment, the politicians in office today may accept the constraints of an independent judiciary, the constraints that imposes upon them, in the knowledge that when the political winds change, the same courts will impose similar constraints on their political opponents. All of this is to say nothing of the costs that can be incurred where a politician is widely viewed as having failed to respect the independence of courts, as vividly illustrated in 2016 when legal elites and political opponents roundly criticised the then Lord Chancellor Liz Truss during the Enemies of the People episode, a matter to which I'll return later. Now, the actual mix of reasons why our politicians generally respect the independence of courts is no doubt complex, with no definitive study that can tell us why this is so as a matter of history, empiricism, or theory. The point is that most of the time, most politicians have reasons related to the common interest and their own self-interest to behave in ways that foster independence. Now, none of this denies that tensions will arise between politicians and judges from time to time. Tensions are inevitable. What we need to do is to grasp how those tensions relate to judicial independence, which takes me to a third common mistake. It's a mistake to assume that tensions are a threat to judicial independence or evidence of a weakening of a political commitment to it. Rather, the inevitability of tensions is part of the reason why we insist on judicial independence in the first place. Judges enjoy security of tenure, protected remuneration, immunity, and other structural protections associated with judicial independence precisely because tensions will arise now and again. These protections create the space for judges to decide independently in the expectation that tensions are inevitable. Now, of course, tensions are only ever part of the picture, since most of the time most politicians fully respect and comply with judicial independence. At the same time, tensions are a feature, not a bug, of a constitutional system where the rule of law flourishes. Since judicial decisions in high-profile cases that involve governmental actors being held to account will sometimes lead to short-term strain between the political class and the judicial class. As I see it, there's a tendency for some lawyers to assume that the mere fact of tensions is itself a threat to judicial independence, whereas such tensions are better seen as a reason for, and indeed a byproduct of, judicial independence. Differently put, tensions are to judicial independence what turbulence is to a modern jetliner. Entirely expected, possibly very uncomfortable for those with a nervous disposition, but posing no structural challenge, and normally nothing more than a passing interlude. Now, some might criticize this as complacent, cautioning that we must remain alert to the possibility that tensions will spill over into outright attacks by politicians on our judges. Certainly, we must remain attentive to the possibility that politicians might pursue improper challenges to judicial authority. But we should also take comfort from history, which suggests that while the political forces that help to create an independent judiciary are complex and difficult to capture, once up and running, political inertia can serve to protect an independent judiciary. This political inertia flows from the many reasons just discussed why independent courts are attractive to politicians and the public. It also reflects the fact that a serious threat to judicial independence, such as an attempt to erode security of judicial tenure, would almost certainly be controversial, face resistance from political opponents and powerful legal elites, and require legislative action, all of which would raise the stake for anyone considering such a course. In the UK, tensions have tended to centre around occasional political criticism of judicial decisions, which takes us to our fourth mistake. It's a mistake to invoke judicial independence in ways that squeeze out political scrutiny of court judgments. Now, few of us like being criticised, and criticism for just doing our job can be tough to take. But judges exercise public power, and in an open, democratic society, this means being subject to public scrutiny. Such scrutiny will sometimes be coloured by the rough and tumble of political life, which means that criticism may well be emotive, over the top, and even disagreeable. Many lawyers seem to struggle to accept this, with their impulse to deem certain criticism as out of bounds, often citing judicial independence to justify this. We saw an example in 2011 when David Cameron and Theresa May, then the PM and Home Secretary, they both described themselves as being appalled by the Supreme Court's decision in RF, which concerned the notification requirements for sexual offenders. For many legal elites, this criticism was beyond the pale, and the then President of the Supreme Court and then Lord Chief Justice each reportedly wrote to the Lord Chancellor to express their concerns. To my mind, that was an overreaction that obscured that ministers have a duty to articulate their concerns about judicial decisions. It's inconsistent with democratic self-government to insist that ministers and politicians keep their criticisms to themselves. They must necessarily criticize the law to justify changes to it. And where that law is encapsulated in court judgments, then this necessarily involves criticizing judicial decisions. Of course, ideally, criticism should be reasoned, temperate, directed towards the judgments and not the judges who rendered them. But it's also unreasonable as well as unrealistic, to expect ministers and politicians to criticize court decisions as if they were lawyers arguing in court. Politicians speak in a different register, often using strong language to express their views, partly to ensure that their comments attract public attention. It was entirely appropriate for the Prime Minister and the Home Secretary to describe themselves as appalled by the decision in RF. For sure, this was muscular criticism of a judgment on a matter of high political salience, but it was in no way improper, despite the furore that accompanied it in legal circles. I say all this buoyed by the lack of evidence in our constitutional history that suggests that occasional political criticism of judges or their judgments has imperiled judicial independence. Fortunately, indeed deliberately, our judges are made of sterner stuff. And any judge who feels improperly or excessively pressured following ministerial criticism of this or that judgment may be ill-equipped for judicial office. Now, true, the prohibition on responding publicly to criticism of them or their decisions may leave a judge feeling vulnerable. Here, it's important to recall that our polity has taken great care to confer on judges formal protections precisely because politicians might criticize them from time to time. It's wrong, and indeed it's to misunderstand the very idea of and rationale for judicial independence, to insist that on top of those formal protections, the polity must also prohibit criticism of judicial decisions. The answer is instead for legal elites to keep political criticism in proper perspective. I suggest that this requires we follow the advice of Robert J. Sharp, a former judge in the Court of Appeal for Ontario. Sharp reminds us that, quote, judicial independence does not shield judges from public scrutiny, and there are times when judges must simply grin and bear the sting of public criticism. Sharp continues by observing that it takes courage to make a decision that judges know will be unpopular, and that's precisely why judges are given the protections of judicial independence. What this means, he continues, is that judicial independence cannot spare judges from the pains of public censure, but it should fortify their determination to decide according to law. Now, it's difficult to talk about public criticism of courts without mentioning the Daily Mail's Enemy of the People headline in November 2016, in the immediate aftermath of the Divisional Court's decision in the Article 50 case. The dominant view amongst the legal establishment was that this was not just criticism, but abuse, and as such corrosive to public confidence in the judiciary and the rule of law. For my part, I viewed that headline as both very ill-advised and excessive, as indeed was much of the coverage of the ins and outs of the Brexit process. Given the political temperature in the aftermath of the EU referendum, it is unsurprising and regrettable that the Lord Chief Justice felt it necessary for the first time to liaise with the police to ensure appropriate security arrangements were in place. But I don't see the media coverage as any sort of threat to judicial independence. It did not undermine any of its common indicia, such as security of tenure, nor was it likely to influence the justices who heard the subsequent appeal in the Supreme Court. As for the claim that the media coverage risked denting public confidence in the judiciary, reflecting on our tradition of judicial independence should have reassured us that there was little reason to fear this. Subsequent events also suggest that the concern was misplaced. The public response was extremely muted when the Supreme Court dismissed the government's appeal. Subsequent academic research also suggests that the media coverage did not undermine public confidence in our judges. The Enemies of the People episode was also a lightning rod for debates about the Lord Chancellor. Here, the dominant view was that Liz Truss had spectacularly failed in her role as Lord Chancellor by not publicly condemning the media coverage, charged as she was with a statutory duty to uphold judicial independence. This trades on a number of assumptions, including that there was a clear and definite need to defend judicial independence, that this need triggered the Lord Chancellor's statutory duty to uphold judicial independence, that it was only possible to vindicate this duty by issuing a press statement condemning the media coverage, that any such statement had to be issued within hours of the headline to satisfy that duty, that only the Lord Chancellor was able to take effective action here to defend the judiciary, and that the pre-2005 occupants of the office of Lord Chancellor would have instinctively recognised the need to defend the judges promptly and publicly. Each of those assumptions is questionable, as I argued at the time in a short paper for Policy Exchange. And each also points to a fifth common mistake. It's a mistake to cling to what we might term a saviour theory of the Lord Chancellor, which greatly exaggerates that office's role as guardian of judicial independence. The saviour theory encourages us to assume that the independence of the judiciary stands or falls on whether the Lord Chancellor visibly, energetically, and proactively defends the judges from every conceivable challenge, whether or not that challenge emanates from inside government. This saviour theory, as I see it, is perversely strong today. Perversely strong because the logic of the reforms to the office in 2005 was to dilute its significance. Yet many legal elites now seem to pay greater attention to this role. Despite the 2005 reforms, many lawyers and judges seem to view the willingness of Lord Chancellors to defend judges as a critical barometer of judicial independence. This outside focus on a single office is both unhelpful and unhealthy. It overlooks other guardians of judicial independence and the rule of law that have long existed inside government: law officers, parliamentary council. Other more recently established bodies also now inhabit the judicial ecosystem, such as the Judicial Appointments Commission and the Judicial Conduct Investigations Office, each of which contribute in their own way to a culture of independence. The saviour theory also obscures the important role that judges have long played in defending their own independence, as illustrated through the years by senior judges intervening decisively often in policy debates affecting the constitutional position of the judiciary. Today, senior judicial leaders have various tools, both formal and informal, available to them, including statutory power to lay written representations before Parliament, the ability to make a high-profile media intervention, and the standing to request a meeting with the Prime Minister. Now, none of this should be taken to deny that post-2005 Lord Chancellors can and do protect judicial independence. They can, and they have. But they are political guardians, not only in the banal sense that they are conventional politicians, but also in the more interesting sense that their willingness and capacity to defend the judiciary will be shaped by and responsive to politics. They'll tend to be reactive guardians, insofar as there may be occasions where ministers propose policies that arguably interfere with the administration of justice. It's likely to be pressure from inside the political system that ultimately impels the Lord Chancellor to induce his or her colleagues to ditch the offending policy rather than some internal instinct that that's the right thing to do. As a conventional politician, a Lord Chancellor's decision about when and how to safeguard judicial independence may be more likely to be affected by partisan considerations, with private rebukes of ministerial colleagues more likely than public statements. It may also be that these days Lord Chancellors will do the right thing by defending the judges where it's appropriate to do so, only after exhausting all other possibilities. Here it's worth noting that Liz Truss was later reported to have privately reminded ministerial colleagues on the morning of the Enemies of the People headline of the importance of judicial independence. She was reported to have encouraged them to avoid commenting on the Divisional Court's decision whilst the government prepared its appeal. It's also worth recalling that Liz Truss ultimately did issue a public statement affirming the importance of judicial independence within 72 hours of the decision in Miller 1, albeit in weaker terms than many lawyers would have liked. Thinking about this office encouraged us to grasp the importance to our tradition of judicial independence of an engaged executive. this takes us to our sixth and final mistake, which is to assume that the most pressing threat to an independent judiciary lies in political interference, whereas political indifference might pose a more serious long-term challenge. Our tradition of judicial independence requires broad-based support for independent judges, where politicians view well-functioning and appropriately financed courts not as an inconvenience, but as an indispensable to the rule of law and thus to the health of the political system. Critical to sustaining this political constituency for an independent judiciary is an informed executive, where ministers take seriously their responsibility for the financial and administrative health of the courts. We want ministers to recognise courts as an essential service, to grasp the need to invest in technology, infrastructure, staff, and the other support necessary for the fair, efficient, and independent administration of justice. This bears emphasis since the regulatory space in which policy relating to judges and courts is now made has been reshaped over the last 20 years. That regulatory space is today much more formal, transparent, and open, with new mechanisms of accountability for senior judicial leaders to give an account of their stewardship of the courts. There's also now a wide range of actors involved in designing, implementing, and overseeing policy. Much of this was enabled by scaling back the role of ministers in funding, managing, and leading the court system. To be clear, Lord Chancellors continue to exercise extensive ministerial responsibilities for the courts, but most are systemic in nature, with ministers much less involved in the nitty-gritty of decision-making. The result is an increasingly formal separation of powers between the political and judicial branches. Not only is there today much less scope for ministers to misuse their residual powers to inappropriately influence the judiciary, but a greater challenge perhaps lies in ensuring that they're engaged with and sufficiently knowledgeable about the work of and pressures on judges and the courts. In short, the challenge today is to find fruitful ways of keeping ministers invested in the judiciary and the courts. One such way could be to enlarge the role of the Lord Chancellor in selections to senior judicial positions, as Professor Eakins and I argued in a paper last year for Policy Exchange. Under the current arrangements for senior selections, the Lord Chancellor has little meaningful involvement in individual selection decisions. In our paper, we argued that the Constitutional Reform Act should be amended to require selection panels to produce a shortlist from which the Lord Chancellor would then select the successful candidate. Selection panels would still identify the candidates for the shortlist, which would provide assurance that the persons appointed have the qualifications and temperament to serve. At the same time, a shortlist would confer meaningful discretion on the Lord Chancellor. We suggested several reasons for this, one of which related to judicial independence. The current arrangements for selecting senior judges seem to be premised on the assumption that judicial independence requires that senior judges themselves have the decisive say, tempered only by involving lay people and practitioners on selection bodies, with little role for ministers. This trades on an impoverished account of judicial independence, one instinctively suspicious of ministers, one which neglects the need for a political coalition behind an independent judiciary. The better view is to recognise the vital part that an engaged executive plays in sustaining a political coalition for independent courts. A meaningful role for the Lord Chancellor could help to foster the executive's trust and confidence in the judiciary and the court system. It could help to reassure ministers about the quality of the individuals selected for the very highest judicial offices, and more generally, about the robustness of the recruitment process. To be sure, this proposal is far from a silver bullet in ensuring that ministers remain committed to an independent judiciary. And I'm mindful not to repeat the saviour theory just discussed when exploring new ways of trying to ensure that the executive remains interested in, concerned about the judicial system. But Richard and I argued that our proposal could help to sustain ministerial understanding of the roles performed by senior judges. It also both reflect and reinforce the real stake that ministers have in the effective working of independent courts. One objection might be that this risks ministers appointing partisan lawyers to senior judicial office. But there's no empirical evidence to substantiate this. For most of the last 75 years, partisan factors have been wholly absent from judicial selections, including over the last 15 years, where successive Lord Chancellors have approached their very residual role in senior selections with extreme caution. Perhaps more to the point, the security of tenure that all senior judges enjoy mean that every serious politician recognises that there's no effective way to ensure in advance that judges will toe a partisan line. So those are 6 common mistakes about judicial independence. The question posed in this title was, what is judicial independence? A beguilingly simple question, not easily answered. It's a question that needs to be situated in time, place, and perspective. Tonight, I've suggested that in the specific context of our own constitutional system, judicial independence is a tradition built on a long-standing political commitment to independent courts. This tradition has been transmitted between successive generations of politicians and still shapes practices, values, attitudes, and behaviours. To understand judicial independence in our contemporary constitution requires us to develop a good knack for that tradition. Ultimately, as I see it, there are several common mistakes which surface in our public debates that distorts how we understand that tradition. Now, the 6 mistakes I've outlined tonight aren't the only ones for concern. Others include some who confuse judicial independence with judicial self-interest, the tendency to lose sight of the ways in which the independence of individual judges can be imperiled by the acts and decisions of other judges. But the 6 mistakes that I've highlighted are ones that, on my reading, seem especially influential amongst legal elites. Each suggests a failure to grasp the significance of that deep-seated commitment in our political culture to respecting independent judicial decision-making. This is regrettable, since it can lead some to worry that our tradition of judicial independence is increasingly fragile, when perhaps it's their own understanding of that tradition which is shaky. That shaky understanding can culminate not only in over-the-top defences of our courts, but also unsound claims about the relationship between political action and judicial independence. It'd be wrong, for example, to suggest that judicial independence prohibits perfectly legitimate political actions such as legislation that reverses specific judgments, legislation that ousts judicial review in particular domains, or legislation that repeals or amends constitutional statutes, such as the Human Rights Act. Such legislative action may or may not be desirable, but it in no way undercuts our tradition of judicial independence. I began this lecture by observing that the critique of ascendant judicial power, articulated by Policy Exchange's Judicial Power Project, is not only consistent with, but motivated by, a commitment to judicial independence. I conclude by amplifying this. At the heart of the project lies a keen appreciation of the deep-rooted, broad-based political commitment that I've argued underpins our tradition of judicial independence. For the reasons canvassed in this lecture, that commitment is much richer and more robust than many assume. But it's important to be attentive to that political commitment, and that's what drives much of the work of the project. For the surest way for this political commitment to flourish, and for our tradition of judicial independence to subsist through time, the surest way is for judges to ensure that their judgments are well supported by legal principle and precedent. Equally, the quickest way for that commitment to begin to fray is if courts make decisions that are clearly not rooted in settled principle and precedent, and which fail to respect constitutional fundamentals such as parliamentary sovereignty. This doesn't mean that judges should pull their punches in high-profile or controversial cases, where keeping faith with positive law requires them to uphold the legal rights of those in dispute with governmental agencies. Of course not. Deciding cases according to positive law and through open legal proceedings is what makes an independent judiciary indispensable to the rule of law. But the closer that courts hew to positive law, settled constitutional principle, and ultimately to the proper limits of the judicial function, the more that they can expect the political commitment to their independence to thrive. Thank you.
Well, thank you, Graham. We have time for some questions, and I should remind those who are joining us online to raise your virtual hand, and we'll try to come to you as well. Do I have questions in the room? If you do, please raise your hand. Lady at the back there, please. The microphone being brought to you, and it'd be great if you just say who you are and ask your question briefly. Thank you.
What if your assumption is wrong and that politicians don't have that impartial interest in preserving the independent judiciary that you say that they have? Or there comes a time when that changes, and if you've given greater power over judicial appointment to the politicians, and secondly, if the role of Lord Chancellor is to all intents and purposes pointless now, why not scrap it instead of giving them greater things to do?
Thank you for those questions. Well, first off, what if the assumptions driving my lecture are wrong? Well, what I've tried to do is suggest that there is evidence, there is history, and there is theory underpinning the critique that I have offered. Like every collection of evidence, every historical account, and every theoretical explanation, there will be imperfections with it. But I've tried to explain why there are a series of forces that encourage most politicians most of the time to behave in ways that actually secures the independent judiciary, much of which happens out of sight if we're focusing on the shiny object of when there's a bit of a scuffle about this or that judgment. I'm encouraging us to look at the bigger picture and keep the scuffle in proper perspective. You asked me, what if the picture I'm painting changes? Well, one of the reasons I'm giving this lecture is because I'm keen for our tradition of judicial independence to continue to thrive. I'm concerned that one of the reasons why it may not thrive is if we have over-the-top defences of our judges, which encourages politicians to question their own ability to behave in ways that promote independence, that doesn't actually incentivize them to understand their obligations. And one of the curious things about many of the over-the-top defences of our courts is that they actually encourage us to be much more sceptical about the independence of our judges. Don't criticise these judges. They may not decide impartially. Wrong. There's independent judges surrounded by a series of formal protections that are designed to ensure that they decide independently. And in our constitutional tradition, they do, and they have done for a very long time. So I want to be attentive to the political commitment that helps to sustain that.
We have a number of questions in the room, a number of people online who want to come in. Can we have Charles Wyde, retired senior circuit judge, if he is available? If you're there, Charles, then now is your moment.
Can you hear me? Can you hear me?
We can, thank you. Fire away.
Good. It seems to me it's very important that the judiciary keeps its own house in order. And I'm concerned about the risk to judicial independence and accountability from the training of judges. The Equal Treatment Bench Book is an example. It's become an immensely long, partly socio-political treatise. And the influence of campaigning organisations has been pretty clear. And the Judicial College has refused to disclose its sources.
So towards the end of the lecture there, I intimated that there is a series of other concerns that we need to be mindful of, and they include the potential for the independence of individual judges to be imperiled by a move towards greater corporatism within the judiciary as a whole. And as with all potential challenges to our culture of independence, it's important to be mindful of that. That having been said, work that colleagues and I did between 2010 and 2015, Professor Robert Hazel, Mallison, and Professor Kate Mallison and Dr. Patrick O'Brien, our overall conclusion was that the move towards a more formal, supportive system of judicial training was to be welcomed. It recognised that the pressures on judges today are very different than the case 20, 30, 40 years ago. The expectations for fair and efficient and consistent administration of justice mean that there needs to be greater articulation of what that means day to day for individual judges and greater support. I'm not on top of the individual details of the example that you meant, but by and large, I think the move towards greater training, greater support recognises the day-to-day reality of the pressures that judges are under.
Many more hands here. Lord Folks, down here. Can we take three in a row, actually? So you first, sir, and then a lady up here in the front, and then the gentleman in green.
Thank you very much for your excellent lecture. There's one thing I wanted to ask you about in terms of the independence of the judiciary, and that's the independence of judges, independence from each other, and how important you think dissent is. Now, you quite understandably said the judges have got to be robust about criticism they receive. But is it not understandable that in the face of criticism, there might be a certain element of groupthink from judges embattled by potential criticism? One of the problems, in some people's eyes, of a unanimous decision in the Miller 2 case was all judges came to the same conclusion in the Supreme Court, notwithstanding an extremely elegant and persuasive judgment from the divisional court. How important is there for there to be dissent?
Thank you. And then if we can proceed to the lady up here in the second row. Sorry. Thank you.
Hello. So,
sorry, name and organisation?
Sophia Greenblatt. I'm head of research for College Green Group.
Thank you.
I think probably one of the main ideas, I'm also, by the way, a law student at the moment, which makes this lecture even more fascinating. I'm sure that we all understand that judicial independence is sort of one of the fundamental tenets of our Constitution, being the rule of law. And I'm curious, with sort of the keenness of certain politicians to include ouster clauses in certain pieces of legislation, what you think that the impact of that is on judicial independence, where basically we're attempting to exclude judges from making decisions on certain issues while simultaneously attempting to uphold their independence to be able to make decisions in the first place.
Thank you. And this last question was the gentleman in green. Sam, go ahead, five.
Thank you. My name is Simon Gams. I'm a 61-year-old law student. I wanted to actually pick up on the journalist lady, because you mentioned at the very beginning of your lecture about the political and legal context which judges operate on, and also public policy, and then the social logic of the courts to rule on cases, and also the cultural logic. It wasn't until within your fourth point you talked about the press, specifically the Daily Mail and the Eminence of the People headline, which is an obvious pop. It sells newspapers, a headline like that. But to what extent are newspapers or the press in this country, to what extent do they influence this discussion? Because you only actually refer to the press once. In terms of, to what extent is there political and judicial, more political independence from the press, or that is not impacted by the press and public opinion, which again is in the main dictated by the press, it seems today, if that makes sense.
A few questions there, Graham. Go for it.
Well, thanks, Richard. I thought I got away from law students. As head of a law school, I know that they often ask the most difficult questions. No offence, Lord Fox. I agree, Lord Fox, of the importance of dissent, especially within our common law tradition. Not only does it add richness and texture to the way that we understand and develop the law, but I think it has rightly been identified as an important buttress for the independence of individual judges. More generally, there's a couple of questions of heart on the threat that other judges can pose to each other, and it's important to be mindful of that. My sense is, again, that many of the protections that exist are designed to protect judges from each other as well. I would commend everyone to read a lecture by Dyson Hayden about 10 years ago, and it's also published in the LQR. I think it's called The Threat from Within. It rewards close reading. On ouster clauses, I regard those, I'm sure Richard would share the view, as an appropriate exercise of political responsibility, at the moment designed to address what many politicians and academics and some judges view as overexpansion of judicial power in recent years. Now, like any good law student, you're encouraging us to think about the extreme situation, or do you want an independent judiciary that has no jurisdiction at all? No, of course we don't. It's a lovely little logical conundrum. But again, my response to that would be think about the theory, think about the history, think about the empiricism, and ask ourselves, how real is that threat? And if we are concerned about that threat, what is the best solution to it? It is for courts to hew closely to the traditional limits of their role, to decide according to settled legal principle, and to respect constitutional fundamentals. And then we'll find that concern or the shift towards ouster clauses will dampen. The third question, I think, Richard, was about the media. And again, I think there's often, not just around the enemies of the people episode, but there's other examples that we could draw out from the 1980s and 90s about quite aggressive headlines and the discomfort that caused judges. But again, we need a sense of perspective that is, again, part of the reason why we confer upon judges a whole host of formal protections that we don't give to other important constitutional actors. Those protections obtain when there's media criticism as well. Now, for sure, we live in a different media age today, and judges, like many other actors in our country, are having to think about how to deal with information overload, with social media, with the decline of deference. And for the most part, like many of our institutions, I think the judges are doing a pretty good job in navigating what can be choppy waters. It's for the rest of us, I think, to try and retain a sense of perspective.
I would like to give our last question, if I may, to our online audience, given there are several questions coming in. So Michael Burton, if you are able to ask us your question, if you can keep it brief, I'd be most grateful. Assuming you're still there. It seems not, in which case I'm going to invite Lord Hodge to deliver a vote of thanks to bring our evening to a conclusion. Thank you, Lord Hodge.
Well, thank you, Professor G, for your lucid and thought-provoking address, and thank you, Lord Goodson, for your invitation for me to come this evening to give the vote of thanks. I was pleased that your 10 mistakes were shrunk to 6 and that they didn't over time move in the other direction, because it reminded me of the famous intervention of the old French politician Clemenceau when faced with Woodrow Wilson's 14 points for world peace after the First World War. 14, the old man said, mais le bon Dieu n'a que 10. As I'm a serving member of the judiciary, it may come as no surprise that I don't agree with some of the premises of the Judicial Power Project and would question the assertion that judges have departed from settled legal principle in their judgments on matters of public law. But I do recognise the legitimacy and value of informed debate on the exercise of public power by judges. And there's a great deal of what you've said concerning judicial independence with which I agree, and I believe almost all judges would agree. The big picture, I think, is a norm of political respect for judicial independence, but senior judges must work hard to protect that independence. The rule of law is indeed essential for maintaining a successful democracy, and judicial independence is crucial to that rule of law. But formal rules alone can't maintain the rule of law. There has to be a buy-in by politicians and the public. And we have a need to preserve a political culture which upholds the rule of law. It is, I think, important that members of Parliament, including members who serve in the executive branch of government and the wider public, understand how they benefit from the rule of law. At a time when people question the legitimacy of public institutions, there's a need for both politicians and judges to reach out to the public to explain what they do. As you know, I agree with you that the rule of law in this country is a political achievement. It's interesting to recall that in the 17th century, when there only were 12 judges in the High Court, King Charles II dismissed 11 judges in his last 11 years in office, last year in power, and his brother, James II, dismissed 12. He achieved this in a 3-year reign before he was ousted by the Glorious Revolution. And that revolution established or re-established representative government and planted the seeds for our modern democracy. Such behaviour by the king was, as you said, then outlawed. And the success of democratic government and the independence of the judiciary, I think, can be seen as intimately connected. I agree also that maintaining the reality of judicial impartiality and the awareness of the public that judges are impartial and not political players are essential to the rule of law. Judges must leave their personal views on matters of public policy outside the door of the court. And in my experience, they do so. Judges seek to decide cases according to the law. Now, not every decision a judge will take will find favour with everyone. It's an important component of our democracy that if Parliament disagrees with a judge's conclusions on the law, it can legislate to change the law. Judicial review challenges to public authorities no doubt come at a cost to the government, both in the use of resources of cash and of personnel. But it is only a very small proportion of the workload of the Supreme Court. According to the annual report, it was less than 10% of our work in the legal year 2020-2021. And most importantly, as you recognise, the judicial review process upholds the legitimacy of government in our country. In modern Britain, most of the powers which the government and other public bodies exercise are conferred by Parliament, and the courts recognise and uphold the centrality of Parliament in our Constitution. Parliament is the ultimate source of the political legitimacy of governments. Ministers are responsible to Parliament for the formation and execution of their policies. More often than not, challenges that a minister or a public official has acted in an illegal manner are made when it's claimed that the government or a public body has not complied with the powers which Parliament has conferred. The courts thus have a role in seeing that Parliament's laws are respected. Both politicians and judges have an interest in and contribute in their own way to the maintenance of the rule of law and good government. The Supreme Court, through the civil servants who administer the court, enjoys a good day-to-day working relationship with the Ministry of Justice and other government departments. And the justices, and in particular the President of the Court, enjoys a good relationship with the Lord Chancellor in pursuing these aims. Now, tensions between the judiciary and the executive may arise, as you say, in a very small minority of cases, and as you say, that's to be expected. What's important is the way in which disagreement is expressed if a politician or commentator doesn't like the outcome of a legal case. Within Parliament, there are, of course, conventions as to how such disagreement is expressed. But sometimes a politician or a commentator may go further and, usually by implication, suggest that judges have made a decision for an improper reason, such as by giving effect to their personal views on a policy. Judges have, by convention, not responded personally to such attacks because to do so would take us into the political arena and damage confidence in our impartiality. It's here that I may respectfully, I hope, take issue with something you identify as a mistake. And I hope I can do so without being seen as perverse or unhealthy. And that is the saviour theory of the Lord Chancellors. Lord Chancellor, judges do depend upon the Lord Chancellor to speak out for them promptly when intemperate and unfair attacks are made on the judiciary. He has a specific statutory duty to uphold the rule of law and the independence of the judiciary, and law officers and others no doubt have a role to play also in protecting judicial independence. But it falls on the Lord Chancellor to speak out when public debate becomes intemperate and has the potential to damage respect for the rule of law. You described the views expressed by lawyers as those of the legal elites. I would respectfully question that. The legal profession contains people with a very wide range of views, but few would question the need in a crisis for the Lord Chancellor to speak out. Now, in a healthy democracy, both judges and politicians can expect and must accept robust criticism and disagreement. But it is my view that there is a specific duty on the Lord Chancellor to act promptly when lines are crossed. An unfair or inflammatory charge against a judge in the media or by a politician or by a commentator which isn't promptly answered will lead some people to expect that what is said is true. As you identified in your book with Robert Hazel, Kate Mallinson and Patrick O'Brien, there is a need to maintain within our political system a general attitude of respect for the law and an appreciation of the importance of a well-functioning and independent legal system. Judges, I think, must also be alive to the pressures of the political process and recognise the constitutional and institutional limitations on their role. Politicians and judges mustn't be indifferent to each other's role in our democracy. The Supreme Court is seeking to play its part in improving mutual understanding by engaging with the parliamentary authorities, and justices have recently had a very successful meeting with members of the Justice Committee of the House of Commons. In conclusion, I agree with you. Ministers, politicians and judges and the public have a common interest in upholding the rule of law. And it's a critical component of effective government in democracy that rule of law is upheld. Informed debate on the rule of law and on judicial independence has an important role to play in that task. You have contributed to that tonight. So thank you on behalf of all of us for your stimulating lecture.